Case number 522569, matter of Weber versus State University of New York.
The appellant would reserve 1 minute in rebuttal. May it please the court, my name is Arthur Scheuerman. I represent the petitioner here.
Mr. Sherman, you and your client acknowledged that the victim did not verbally consent to intercourse. Is that correct?
She did not say, yes, I will have sex with you. That is correct.
Verbally, so you agree with that?
Well, I say there were other verbal signs, particularly the proposition that if you go down that slide, I will have sex with you. That was followed, juxtaposed moments before to consensual oral sex.
I just want to clearly understand your position on whether your client is contesting that he did not get verbal consent from the woman that he engaged in intercourse with.
I would submit to you, he did not get verbal affirmative consent that I would have sex with you.
So what behavior is it that you're relying on? Because that's the only other thing that the code would states could be indicative of consent, correct?
No, I disagree with that. The code says verbal consent can be in many different forms. And as I just articulated to the court, she did proposition to go home with him.
Well, are we mixing two different events?
No, I think it's
There
one.
was the oral sex in the playground, which I think the complainant admitted was mostly consensual. But wasn't there sex later?
There was sex later, and
So
prior-
but that's the event, I think, that's at issue here, not so much the playground.
I think the whole thing, the whole 2-hour period has to be looked at as one transaction.
So consent in the playground signifies consent later in the bedroom.
Well, I think in the bedroom, what do we have? We have additional consent in the form of her saying, do you want me to wear a condom? And she affirmatively says yes. If she had any desire to say no, which the code at the time required, she should have voiced that no then.
Well, she explained that she said yes because she concluded that she would rather be raped while your client was wearing a condom than raped while he was not wearing a condom.
And I would submit to you here, the most important piece of evidence is that of the accuser's best friend.
Let me digress a minute, though. You stated a minute ago that verbal consent, under the code, verbal consent can be in many different forms. What can you point me? Wait, let me ask my question. Please point me to the language in the code that you're relying on for that proposition, that verbal consent can be in many different forms.
It says verbal consent, but at the time, verbal consent could be questions that relate to an intent, and I'm submitting to the court, those questions would include the proposition in the playground, the idea of having.
So notwithstanding that the code specifically says that indicators of consent do not include silenced or past sexual relationships, you're relying on the fact that they had consensual sex previously that night in the playground as a way of showing that there was consent for the sex acts that occurred later in the bedroom?
That was part of it, yes.
Well, how do you reconcile that position? How do you reconcile that position with the language of the code that I just referenced?
Because the code says that consent is spoken words or behavior.
Right.
That's a broad
That
term.
indicates without doubt. to each
Without
party.
doubt. And here, she did not indicate, the record is not established that she did not consent to that. And she testified, I never told him I did not want to have sex with him.
So do you think this, when you get to the bedroom, do you think this is a credibility issue?
I think
He
in part it is.
says she consented and she says she doesn't.
And you know why I believe it is?
No, I don't know why, but I want to ask another question.
Okay, sure.
If it is a consent issue, he left the bedroom for a minute, the way I understand it, and came back.
Several minutes.
Okay. In that time frame, she texts her friends that she thinks she's going to get raped, how does anyone disregard that when they're looking to determine who's telling the truth?
I would ask you to look at the following testimony and evidence that was entered. At 2:15, after the consensual oral sex, she has a 2-minute conversation with her best friend. Her best friend
Could you just go
testified-
back to tell me?
No, I'm dead. Can I lead into what I'm trying to make that point? Her friend talks to her for 2 minutes. Her friend testified, I did not believe she was in danger. Okay, 2:18 is a text to her roommate saying, using the word rape. At 2:20, there is a text to the other coach saying rape. Significantly, at 2:23, they're in that room. She talks to her best friend for over 30 seconds. And her friend testified, I never thought she was in danger. I never thought that she was doing anything against her will. That's the testimony, and that's the evidence that shows she consented.
Is this the friend, when you're making reference to the friend, is this the incident where the phone was knocked out of her hand while she was on the call?
No, because we don't know what that person said because she never testified. And the state and the college had power. This is the friend who was with her the whole time.
Let me digress a minute. You were asked questions about whether they were credibility determinations, and isn't the case law clear that the determination of credibility is within the exclusive province of the conduct board?
I think this court is empowered to look at the entire record. I say you have to look at the quality and the quantity of the evidence, and you have to juxtapose that to the violations of the petitioner's due process.
Well, we're
rights.
certainly empowered to look at the entire record. I'm asking
Right.
you about the case law that speaks to credibility determinations in this context.
I think this court is vested with the discretionary power to look through the entire record to seek truth in its innermost parts here. And I would point to you, hearkening back to what Blackstone said 250 years ago. It is better that 10 guilty persons escape than one innocent person suffer. In today's environment, the issue of sexual assault on college campuses appears to reflect the opposite. Better that 10 innocents suffer than one guilty student escape
All right,
punishment.
what's the due process issues that we ought to be
The
looking at?
numerous due process issues came from the Supreme Court decision in 2013. He said, the medical records showed there were substantial areas of cross-examination, particularly the
No, well, we're going to run out of time here. What are the due process issues or violations that occurred at this hearing that impacted on your client?
I think among the most is the failure of the conduct office to allow him to cross-examine her about her ability to perceive the events and about her ability to recall them. She changed her testimony in the 2014 hearing and gave 2 recent fabrications that were never testified to in her prior statements, nor were mentioned in her prior 2013 testimony. That opened the door. Then she claimed she blacked out when was being cross-examined about the inconsistencies of those prior statements. I think at that point, the door was wide open, and that testimony, in conjunction with the court's prior order that these were fertile grounds for examination, should have been examined. I don't understand, for example, why is it that the hearing officer gets certain inculpatory evidence and not the exculpatory evidence prior to the hearing? Why is my client denied the right to testify? They told him in the beginning of that process, you have an opening statement, it's not evidence. Yet, he was never afforded the opportunity to address anything regarding those texts. He was never afforded the opportunity to address other matters that this court, what it basically came down to, my client was presumed guilty. And that hearing, if you listen to the audio tape, and I've tried cases in federal, state court, defended and prosecuted, that was a travesty of some monumental proportion. I'm seeking your help to correct the record. We're in the middle of a campus rape frenzy. We need to correct the problems that we see here.
One of the issues you raised in your brief relative to due process was the order in which the hearing progressed and the manner in which testimony was taken. Can you take a minute to address that?
I think that was more of a minor due process violation. I think what was more substantial to me was the following. When she claimed she blacked out, the next witness was her former best friend, who said again, as I mentioned on the record, that she believed everything was consensual, that she was not in danger. She did it voluntarily to submit to having sexual intercourse with this boy who she met less than 2 hours before. She was denied the opportunity to ask layperson testimony about the alleged victim's intoxication. I think that's a due process violation. I also think the record contains other due process violations that were substantial. That whole aspect of the 2013 admission of the other student, my client's roommate's statement, that wasn't even at the hearing, that she deemed it introduced, and then we have a 20 or 5 or 10 minute segue on hypotheticals?
You want to reserve that minute for rebuttal?
Yes.
Thank you.
Thank you.
May it please the court, I'll address the procedural points my friend on the other side brought up, but before I do, I want to make clear that there is substantial evidence in this record indicating that female student K did not, in fact, consent. And that is the question. The question is consent in fact. This is not a criminal forum. The issue is not mens rea. The issue is not what petitioner reasonably believed. The issue is whether, in fact, female student K consented. And for all the reasons discussed among your honors and my counterpart on the other side, there is substantial evidence indicating that, in fact, she did not.
What was the burden of proof?
The burden of proof was always on the college, and the burden was to show that female student K did not, in fact, agree to sexual intercourse with petitioner.
If this is a he said, she said, and a credibility issue, doesn't this court defer to those decisions made by the board?
This court absolutely defers to decisions made by the board, and to a large extent, this is a he said, she said credibility issue. The only way in which it's not a he said, she said credibility issue is because what she said happens to be backed up by documentary evidence, by the text messages that your honors were discussing with my counterpart on the other side. Also by the hospital records where she stated immediately after the incident that he, quote, forced himself on her, and by hospital staff's, quote, clinical impression that she had indeed been the victim of, quote, a sexual assault. So there's much more than just he said, she said in this case. But if, in another case, it were just he said, she said, you're absolutely right that in any event, we defer to the fact finder. We always defer to the fact finder in questions of credibility.
Your adversary, one of the arguments is that he says his due process rights were violated because he was unable to have the college present all of its witnesses before he was required to participate in the hearing. Can you address that?
Sure. As far as order of presentation of witnesses and other similar procedural questions, the college hearing officer, in this case Dr. Reinfeard, the student hearing advisor, Dr. Reinfeard, is vested by the code with broad responsibility, broad discretion over, quote, all procedural questions, including the manner of presentation of witnesses. But more concretely, there's no prejudice here. After every witness testified, he could have asked to recall witnesses. He never did. So the mere fact that initially these witnesses were presented out of order, he certainly had the opportunity to look to cure that, but he never sought to recall. And another due process.
And he had counsel there with him at this hearing.
Yes, he was counseled throughout, and never sought on the record to recall any of those witnesses after some of the prior witnesses had testified.
And we talked about burden of proof. Talk about, if you would, please, when the accused has to testify first. And doesn't that, or do you think that switches the burden of proof? It's awfully hard to confront the evidence against you when you're forced to go first. And in judicial proceedings, you testify in order on the burden of proof. Why is it reversed in these disciplinary procedures?
It's customary to allow the petitioner, and again, it's not that he testified first and only first. He was given the opportunity, he was not forced to, he was given the opportunity to make an opening statement. He made that opening statement. Then he was allowed, there was a question and response period when he was questioned by the college, by the alleged victim through the college and the like. And then at the end, he was permitted to testify again. After all the evidence had come in, He was permitted to give a closing statement in which he could and did explore much of the evidence that was in the record in this hearing.
Here's what bothers me from a procedural standpoint is oftentimes civilly, criminally, it really doesn't matter. When the person with the burden of proof goes first, the other party doesn't testify, can choose not to testify, can choose maybe not to say something that maybe they shouldn't. And if you switch the order of testimony, you've taken that choice away from the accused. And how is that not a violation of due process?
Well, it's not a violation of due process for the reason with which you prefaced your question. This is not a criminal trial.
No, I said civil or criminal. The person with the burden of proof usually goes first.
Well, again, he had the opportunity to point out if there were any deficiencies in the testimony of the alleged victim.
Well, let me just say another way. Let's say the victim testimony was weak, and the decision was then made, well, then I'm not going to testify. That would maybe be the end of the proceeding, and in this case, by forcing the accused to go first, you've kind of switched, the argument is, you've switched the burden of proof, and I'm not saying I agree with it, but I'm asking you to explain it.
Well, again, I have to respectfully quarrel with your premise. He was not forced to go first. He was given the opportunity to go first. He could have said nothing, waited till all the evidence or lack thereof was in, and then given only testimony during the Q&A exchange and at the closing statement. He was never forced to show his hand or the like at the beginning. Just one more point I'd like to touch on as far
Did his lawyer raise any of these objections or concerns through his client at the hearing?
These objections were preserved. We're not making any sort of preservation argument here, but we don't think they have any resonance on the merits, similar with the restriction, modest as it was, in petitioner's ability to use female student K's hospital records to question her about certain aspects of this case. Contrary to what my friend on the other side says, he was allowed to use those records to question her about her alcohol intake. He never sought to do so. He never sought to do so at the hearing. He submitted a list of proposed questions at pages 420 to 429 of the record beforehand. No questions in there pointing to her alcohol, her intoxication vis-a-vis the information disclosed in her hospital records. In terms of using the hospital records to impeach supposed prior inconsistent statements, he did that. He did that in spades. Both of the excerpts that counsel on the other side mentioned as potential prior inconsistent statements, petitioner at the hearing did point those out, pointed that they were contained in the hospital records, raised that for the finder of fact, and the finder of fact resolved the credibility determinations against his client. And we think, as I was conversing with your honors before, those credibility determinations in large part resolved this case, and on that basis, the college's determination should be confirmed.
Thank you. Mr. Sherman?
Judge McCarthy and Judge Devine, I'm going to address more of the issues that you raised in terms of the order. The code made it clear that he had a right not to testify. Clearly stated that. They forced this 22-year-old young man, without any legal training, facing the enormity of his future life on his hands, to offer testimony or offer an opening statement before.
But how'd they force it? That
They
was
told
my
him.
question. And
They
I know
told
that's
him.
the allegation.
Yeah, they said you have the opportunity to give an opening statement. They never asked him subsequently, after she testified, the accuser, would you like to testify? Never offered him an opportunity because there were gaps in his testimony. For example, did he see her texting? Did he see her with the phone in her hand? That was never explored by the hearing officer whatsoever because they weren't interested in the truth. They came predisposed, and there's testimony in record that the college and SUNY system believed he was guilty. And this was basically his unlawyered attempt to change the presumption of guilty. And I ask you to annul this decision, and more importantly, And given the climate we're in, I ask you to dismiss the case entirely. Thank you very much.
Thank you. Thank you both. Please call the next case.